Hey, welcome to the program, everybody. I'm Mark Wallace, your host here, and your facilitator for this special edition of the People's Show. Hopefully, you all will join in with us. Judge Leonard Murray is going to be joining us in just a few minutes to talk about this special thing that we're trying for the first time called the Legal Hour, where you will be able to post your questions in the live chat. We will read the questions, and Judge Murray will respond to those questions as it relates to legal issues and as it relates to the courts. Of course, we have an election that is underway, and it's very important of these offices that we participate in so that we can elect people that we could hold accountable to delivering for our communities and making sure that our communities are not overlooked. So we want to make sure that everybody has their antennas up, get your information so that when you go to the polls to cast your ballots, that you're voting for the person that you think will be the best person that we could hold accountable to deliver for our communities. Now, of course, there are some seats that are critical. I would say they're all important, but certainly critical that we need to really take a look at. One is being the Board of Review, where Larry Rogers Jr. is running for his sixth term, and Larissa Tucker, who is the person that I am supporting and that I am encouraging us to replace Larry Rogers Jr. because we found that Larry Rogers Jr. has been not a good representative and for our communities, specifically that he has been shifting the burdens of taxes from wealthy property owners downtown, commercial property owners downtown, on to the rest of us, the homeowners in the district. All of the evidence is there. The facts are there. You can see it. You can go to the Cook County Assessor's page. They have a graph to show how much money has been shifted and given to wealthy tax or wealthy property owners, that they have gone in and had their taxes appealed, undervaluing their properties so that they could get lower tax abatements or higher tax abatements to pay lower taxes. And those abatements, we, the homeowners, have to make up the difference. So most people are not even aware. They're not even aware of it. They don't even know about it. And so we need to certainly make sure that we have people in place, just because they look like us, but we have to have the right people in place who look like us. Everybody is interested in electing somebody who looks like them, that we're familiar with, but we want to make sure that we have the right people in place who look like us that are going to represent the interests of our communities. And we can't have people in place like Larry Rogers Jr., who has been a holdover from the Barrios regime, that have been voting against the interest of our communities. That is something that we can't have. We can't be personality driven. We have to be driven based on information. And we've discovered this information. We understand this information. And this is what is happening. It's not anything that's speculative. It's not speculation. This is what is happening, that we're having other people's taxes burdens shifted on our communities that are raising the property taxes for homeowners in our communities on the south side of Chicago and in the south suburbs, in the entire 3rd district. So that is a very important race. So I would hope that when you go to the polls, that you vote for Larissa Tucker and replace Larry Rogers Jr. as the representative for the Board of Review so that wealthy property owners can't buy off these Board of Review commissioners. There's only 3 of them. Larry Rogers Jr. and George Cardenas are 2 people who are completely owned and bought by the tax appeals attorneys, and they vote lockstep in lockstock with each other on behalf of these people who are filing for tax appeals that pay them lots of money into their campaign contributions. Larry Rogers Jr. has got more than $800,000 from tax appeal attorneys. He just recently got a $75,000 political contribution from the tax appeal attorney that is representing the Chicago Bears, who just bought the Arlington racetrack for $194 million, and they're trying to undervalue it at $100 million when it has been assessed that it should not be valued at anything less than $160 million. Even though they demolish the racetrack there, the land, the property is still extraordinarily value. So the value hasn't gone down by 50% because they demolished the property. They paid $194 million for it. And whatever that abatement is, it is going to fall on the rest of us. We should not be bearing the burden of somebody else's real estate property taxes because they don't want to pay their fair share. These are wealthy property owners that have bought property for $194 million, and now they want to devalue it by 50% so they can pay taxes on the assessed valuations of 50% of that property. That's not what we should be happening. That's not what we expect of people who are in elected office to be representative of the office in a fair and equitable base. And Larry Rogers Jr. clearly has not been fair, and he certainly has not been equitable representative of that office for our communities. He's been the bidder, and he's been voting in lockstep for those people who write the biggest checks to his political campaign. And he's done very well by that, as well as other business that they've referred to his private law firm. They don't really care about what business they refer to as private law firm. Is his private law firm is doing well, good for him. No problem with that. But don't sell your law firm to the highest bidder and put the burden on the public. And that is what is happening. That's what's happening. And I'll give you, 2 examples of what Larry Rogers Jr. has been doing in terms of shifting the burden of taxes on our communities. And where the levy for the city of Chicago in 20, well, let me pull it up. Pull this up. Here it is. And I think it was in 2021 and 2022. Let's look at what they did. All right, here it is. In 2021, Board of Review shifted 7 percentage points of the city's $8 billion levy. 7 percentage points of the city's $8 billion levy. The total levy burden on to homeowners. So the way that this happened is they did this by cutting the values on the largest, wealthiest property in the city by more than $500 million a year. And if you spread that across 800,000 homes, that's about $700 a year added to your property taxes. That's what's happening. That's what Larry Rogers has been doing. And this is a rather obscure office that most of us really don't pay any attention to, but they make some very important decisions that impact our lives. So we have to be aware of these things that are happening. All right, so we're going to get into it. I see that Judge Leonard Murray is just joining us, and so we're going to bring him into the studio. Judge Leonard Murray is the current supervising judge at the Cook County at the Circuit Court of Cook County in the building division, and we'll let him talk a little bit about that. And he's also a candidate for the appellate court. And Judge Murray, welcome to the program. We'll bring him right into the studio. Oh, there we go. All right, Judge Murray, how you doing?
Good afternoon, Mark. How are you? Sorry for being a little tardy, but was headed towards West Side to visit with some of Congressman Davis's supporters. So, excuse me, didn't want to disappoint them. So I was able to get in and out of there fairly quickly. But I know it was going to make me just a little late for joining you on the program this afternoon. But
Okay.
Thanks so much for this, and I look forward to engaging with your listeners and viewers.
Fantastic. All right, fantastic. So yeah, so this is the first time that we're doing this, and we're looking forward to doing this on a regular basis with Judge Murray, and we're calling this the People's Show's Legal Hour with Judge Leonard Murray. And so what you will be able to do is you have legal questions. You can write your legal questions into the comment area, and then we will read your questions, and then Judge Murray will respond to that. And so until we do that, let's talk a little bit about what your office does, or your history, Judge Murray. So give the viewers and the listeners some background on you and what you've been doing currently.
Okay. Well, I'm a Chicago kid, born and raised on the South Side. Graduated from DuSable High School, played basketball and baseball there. That's how I financed college. Almost pro. I'm also an Army veteran. Served my country as well as my dad and my two brothers. Uh, uh, Undergraduate degree in economics and accounting. After undergraduate school, I worked for IBM for a few months before I was drafted. Served in the Army for 2 years, including a year in Vietnam. Um Thereafter, I worked for a company. I'm sorry. Thereafter, I went to law school a year after being discharged from the Army. Um, Entered initially University of Wisconsin Law School, got married the summer between first and second years. Then I was able to transfer to Northwestern University Law School, which I was able to successfully complete and graduate from as a member of the Dean's List. After that educational background, I worked for about 7 years for an accounting firm, public accounting firm, then known as Touche Ross. Um, um, in its tax department, worked with a group of folks who worked on taxation of insurance companies and some other high net worth individuals, planning for them. It's okay to avoid taxes but not evade them. So we attempted to have our clients uh, uh, pay their fair share, but based on their economic activity, the least that was possible. Um, then after that period of time, I went into private practice of law, which I did until I became a judge in 2007. Since 2007, my assignments have included traffic court for a couple months. Then thereafter, I presided in a forcible entry and detainer room, uh, and I think I have this special um, uh, experience, and that is I presided over 12 double pro se jury trials while in landlord tenant court, meaning both sides in the case, the plaintiff and defendant, were both representing themselves, and normally it's the tenant in landlord tenant court who seeks a jury demand, believing that will buy them more time. Sometimes that's true, sometimes not. But they demanded a jury trial, and I believe that the way we make folks confident in the system is that we give them their day in court. So, despite uh, what some might have believed was a difficult uh, um experience in presiding over a jury trial where both sides were not lawyers and unexperienced in the law, but it wasn't. Uh, the instructions that are given to a jury at the end of the case are the judge's instructions. I had developed my own set of instructions for both uh, uh, non-lawyers and lawyers. So it wasn't a problem at all. And I think the folks went away believing that they had their day in court, uh, and the outcome was one based on a jury that they selected. So I think that's important to develop faith and confidence in the system. Uh, After roughly 6 or 7 years presiding over landlord-tenant cases, um, I was assigned to a jury room for about 4 years, primarily presiding over cases that dealt with personal injury, contract law, and sometimes claims based on defective products. Um, and then for the last 7 years, I've been a presiding judge. I'm sorry, the supervising judge in what's called housing court. It's a misnomer. What we really do in my division is that we deal with health and safety as it pertains to real estate in Cook County. Uh, every inch of real estate in Cook County is subject to our court's jurisdiction, primarily properties in the city of Chicago. It's primarily where our business comes from, although we do have a select group of cases from areas that are unincorporated in Cook County. And whereas most city cases are prosecuted by members of the Corporation Counsel's Office, uh, the cases that emanate from the unincorporated areas of Cook County are prosecuted by the state's attorney's office. So that's been my experience for what is almost 17 years as a judge, and it's unbelievable to me that it's been on the bench that long. It just seems like an eye blink.
Yeah, that must have been really interesting to have to preside over. You said 12 cases where both the litigants were pro se over a jury trial. Being the referee of that must have been really interesting, to
It
say the
was
least.
interesting, but also educational
Mhm.
in that uh, the fact that a jury could fairly evaluate the case, despite the fact that it was a little cumbersome in terms of dealing with both sides not being educated in law or civil procedure, or knowing which questions to ask and arguments to make. But we got through it. And again, I thought it was important that um, those litigants who uh, elected to be tried by a jury rather than a judge um, uh, bore the test of time in terms of being able to get through it and reach an outcome that was consistent with what the evidence was in the testimony.
Yeah, it's very interesting. Very interesting. All right, so you mentioned something that I'm drawing a little bit of a blank on. Yeah, we're talking about where you're served in terms of clients avoiding taxes. I want to start there: avoiding taxes or evading taxes. So help help us understand what is the difference between avoiding taxes and legally in the legal sense of evading taxes.
Well, it is the typical perception that if you evade taxes, then you are not abiding by uh, what the Internal Revenue Code provides in terms of reporting your income fairly. and also reporting your deductions fairly. So in that context, you could be evading taxes. Whereas avoiding taxes, there are certain types of business uh, uh, ventures that you could explore, and investments that you could explore that will help you decrease your taxes from year to year. Um, and that if that's what you're doing, those are legal mechanisms. So you may be avoiding the tax based on your business economic activity versus evading them, where you may be may be involved in some method or mannerism that is not legal.
Okay, so you can use the laws to make sure that you are properly taking advantage of the tax code, but in other words, you can't earn money and then um, not represent those earnings to the federal or to the IRS. That's what is construed as evading taxes.
Correct. So, for example, if you are in a cash business, uh, not many of those left nowadays, but if you are in a legitimate cash business, uh, then even though it's cash and it may be uh, a form of a remuneration that you don't have to put in the bank, you must report it nonetheless. For example, some of uh, the federal government uses tax evasion as a means of prosecuting those who are sometimes involved in criminal activity. Um, so-called um, uh, mechanisms involved in gang activity, drug activity, because those folks don't typically report what their earnings are. So that would be an example of evading taxes, because we're all obligated to report and fairly represent the income that we earn. And if you don't do that, then you are evading taxes versus avoiding, which would be a situation where you report the income and then take permitted deductions against it, including some deductions that might defer the impact of the taxes for a period of time. For example, if you own real estate, um, you can depreciate the real estate in order to reduce, and it's involved in a business enterprise. You can depreciate the real estate, which is an accounting method, in order to reduce your taxable income, so that you pay less taxes. And sometimes it could be zero, depending upon what the venture is that you're engaged in. Versus avoiding taxes. I'm sorry, which is versus evading, where you just don't bother to fairly report what your earnings are.
Okay. All right. So can we talk a little bit about process in terms of what do you see as a judge that people come into court, in particular, the people who come into court without counsel? You have some people who come into court who have counsel, and some people who come into court that are pro se that don't have counsel. Um, what What are your thoughts on people who come into court without counsel?
Well, one of the hardest things in that situation is trying to, um, without crossing the line of being accused of helping one side or the other, is explain what their obligations are if they elect, or maybe just aren't unable to hire a lawyer. Lawyers are not cheap, and most don't work for free. So there's some payment that may be required in order to retain a lawyer. Um, but the process of what occurs in court is not something that is common the common parlance for the ordinary citizen. Um, and let's just run through this example. Let's say you involved in a traffic accident, a car crash case, and even though you are required legally to maintain insurance, you don't or you can't for whatever reason. Um, so and in this instance, that accident is your fault. At least it's alleged to be your fault. So the driver of the other vehicle that's involved in the accident, or it could be a pedestrian who you unfortunately struck while operating the vehicle, uh, would file a lawsuit since you don't have insurance to cover you in the event of that accident, seeking to be compensated for out of pocket costs and maybe the injury that was sustained. Because there are some accidents where the injury sustained is permanent. So to you got the unfortunate experience of looking forward to the need to have medical attention for that injury, maybe for the rest of your life. And how do you prove that up? How do you prove what the value is of a loss in that instance? Well, or defend against it. Um, so normally in those circumstances, well, anybody can give an opinion, um, unless it's an area that requires expertise. Um, you have to be able to uh, suggest uh, why it is you have this opinion, what your belief is based on, because it must pass muster, if you will, in terms of convincing either a judge or a jury that what you say is credible and can be relied on. In evidence in all civil trials, essentially, and even criminal trials, is essentially a sense of is what is being said, is it reliable or not? Um, and uh, the issue then going forward is whether or not, as a pro se litigant, you're able to um, present evidence through testimony and documents that is reliable, something that can be relied on by the trier of fact, that being the judge or jury, uh, that this evidence is such that we can use it in order to support whatever the outcome is. Sometimes that's an outcome favorable to the plaintiff, and it could likewise be an outcome that is not, that is adverse to their interest.
Okay, and then so with respect to someone not having counsel versus someone who has counsel, is there any deference that a judge gives to the person who has counsel over the person who does not have counsel?
Absolutely not. Everyone is equal before the law. I think that's probably a saying that most people have heard. But no, you don't get any advantage by having a lawyer, or disadvantage by not having a lawyer.
So really, the only the for and for the sake of the the audience, is that the only disadvantage that they would have would not be coming from the court, but the disadvantage that they may have is that the other person has a counsel who, has been obviously educated and understands um, the law and how to approach a particular situation to representing their clients within the boundaries of the law, as opposed to somebody who does not. That's the only, which is, you know, considerable, right? Significant. But they're not disadvantaged by the courts. The court is going to make sure that the rules are fairly applied to both sides.
That's accurate, Mark. Our job is to make sure that the process is fair, and it is a process. And while we're able to um, explain the process to a unrepresented litigant, we can't make them um, um, uh, use it in the most efficient manner, because it's going to be a function of what their experience level is, even their own education. Uh, uh, Certainly someone who has a college degree, well, better equipped to deal with a trial than one who is uneducated about certain things, even just the speaking manner, um, uh, writings, and also just putting thoughts together in order to present them to someone else. It's much like an interview. If a person's going in for an interview for a job position, um, the more polished you are in terms of how you present yourself, um, engaging in whoever the interviewer might be, that's going to be an advantage over someone who has no such experience or background to better present themselves. And when you go before a jury, that's essentially what you're doing is presenting yourself. You're selling yourself to that panel of 6 or 12 folks that I'm the most believable person here, as opposed to my opponent, and that's with or without a jury. I'm sorry, with or without a lawyer, I should say. Um, so it's all a function of, can I convey my message? Am I able to well present it? And can I be convincing in terms of expressing my position on what occurred, my version of the facts versus what their version of the facts is.
All right, let's talk about some things specifically in the court, in the building court and housing court, because there are property owners, even though they own property, when they get notices from the city that they have to appear in court, it's very daunting to some people because they think that, oh, I'm going to lose my property because I'm in court, or they're going to condemn my property, even if they have some serious concern. So what is the role what is your role as a judge, and what's the role of housing court or building court for property owners that are called into court to answer certain concerns? What's the real role of the court?
Well, what we do in my division every day is deal with issues of health and safety. So essentially, our role is to make sure that the conditions of a property is such that it's not harmful to those who occupy the space, and likewise, it's not harmful to the neighboring community in general. Um, so, and actually, Illinois is what's referred to as a home rule state. So all the towns, villages, cities that exist, the political divisions that exist in the state, they have the ability to create their own rules as relates to health and safety within their boundaries. So in the city of Chicago, there are two tracks for dealing with issues that relate to. Let's just focus on building code questions now. The first is an administrative process that's been around now for probably 20 years. And rather than going into a court of law, there's an administrative. Uh,
I think we have lost Judge's signal. We'll hopefully get him back. Hopefully we can get him back, that he can get a signal back. All right. So while we're waiting for Judge Murray to get his signal back, we were going through wanting to help people to understand that just because you might have some issues of safety or some inspection issues that you were cited for and you were called into court, that is not the a sign that you're going to lose your building, or that the city is looking to impose some sanctions against you, or to impose a whole bunch of fines. But really the building court or the housing court is there, as Judge Murray was speaking to, about safety issues and health issues, to make sure that your building is in compliance with the health and safety codes of that particular municipality, whether you're in the city of Chicago or another village, that you're meeting the minimum requirements of health and safety codes to ensure that your building is safe for you and your family, or for if you are a landlord, for the tenants and their families. So it's not just set up so that they can look for ways to get fines and fees, but there is a process to making sure that we live and keep our properties safe and healthy for the purposes of the people who live there, as well as for the community where your property is. So that's one of the um, foundations of what the housing and building court is. It's not set up and designed to have this system in place to take your properties. That's not what housing court is about. That's not what building court is about. Not set up to work against you. And in many cases, Judge Murray in particular, who is a supervising judge in housing court or building court, really goes to be fair, but also to make sure that you are doing or actively working towards um, curing whatever the problems are, whatever the concerns are, whatever the health risks are, whatever the safety risks are that is healthy. So it's beneficial to you as well as to the people who live there to make sure that your building meets the requirement of that particular municipality of safety and health. So that's largely what the responsibility of housing court is, and what Judge Murray deals with, day in and day out, as well as he is a supervising judge over the administrative review. And hopefully we get him back. We get the signal back that we will be able to bring him back. Oh, there he is. Okay. All right, Judge Murray, are you back with us?
Yeah, we had some technical issues right there. Yes.
Okay. All right. Um, all right. So we were talking about what you do and the health and safety, and I was just sort of speaking to the audience and telling them that the housing court or the building court is not set up to be a mechanism to take people's property. Um, so, which people who have issues, they're really concerned about whether they're going to lose their property or that. So when does it get to the point um, where you, as the judge, have to make a decision on whether or not this person is able to comply with whatever the minimum requirements are of that particular health and safety concerns for that particular municipality? At that point, and we call them receivers, which is kind of a boogeyman name for a lot of people who really don't understand it. When does that really come into play, or you as a judge, when do you um, um, sort of revert to having to put a receiver in place to manage the property?
Uh, well, there's a broad array of situations in which a receiver can be appointed. Uh, in the main, though, they're appointed to eliminate a health and safety issue. Uh, Sometimes it's structure. Sometimes it's uh, inadequate heat in the property. Um, Another time it could be something even more basic, such as supply of fresh water. Um, but there are a number of different scenarios that the court could consider appointment of a receiver. But essentially, Um, their role is to remedy whatever the health and safety defect exists at that time. Um, there is a call in our division that's what referred to as the heat call. And under the City of Chicago code, uh, there was a certain minimum heat requirement during the winter months, uh, and it's a range, daytime versus overnight. Uh, and if a occupant of a premises um, believes that the uh, ambient temperature within the unit is not sufficient to meet code, then they can register a complaint with the city. There's a 311 call line now that's available to register a complaint, and the city will then send out what's referred to as an inspector, city employee, whose job will be to go out and verify whether or not the complaint is legitimate. And they travel around with these thermometers uh, that they use on site to determine whether or not the heat complaint is valid or not. If we have a heat complaint that is deemed valid, um, and the owner, for whatever reason of the property, either can't or won't remedy the situation, then we can appoint a receiver for heat purposes who would then go out and restore heat if practicable. Now, there may be some circumstances where uh, the cost involved isn't practical, and we may have to employ another mechanism or tool, and that is uh, moving them to a location that is. And normally, what we do in that circumstance is we provide a relocation allowance to give the occupant the money to find new housing that is sufficient to satisfy what their needs are. Um, but the area of receivership is broad. Uh, it can also include an open property where the landlord is not actively involved in the day-to-day management, and we can uh, appoint the receiver to take charge and effectively manage it. Um, and then ultimately, we can get to the point where if there is no active involved management of property, um, it can be forfeited um, by the city to some other person who would in fact be active in the management day to day of the property and make sure that the health and safety issues are complied.
But that again, as you said, there's a process to that, right? And that's
Yeah,
usually,
and that's an
it,
extreme.
yeah. And in most
Yeah,
cases, you're working with the hopefully with the owner. But when you get to the point of receivership, it's really sort of a last resort to where you aren't able to that person for whatever the reasons were not able to mitigate whatever the problems were that you had to put somebody in place to be able to bring the building up to its minimum health and safety codes so that it is not a
yeah.
problem for
I
the
think
people.
it's important. Yeah, I'm sorry. I think it's important that the owner be given the opportunity to comply and spend their own money. Uh, the appointment of receiver typically is going to be a charge greater than would be necessary if the owner took the steps to comply, whatever the condition is themselves. So I always lean that way if possible, to allow the owner to take charge of remedying whatever the defect is.
All right, so because I know that some people think that, oh, I'm going in before the court, they're going to take my property. So, folks, it's not
Yeah.
the housing court, the building court is not set in place to take your property. If your property is forfeited, or if there is somebody who's put in place like a receiver to manage those conditions, it's an absolute last resort that the court has had to revert to. But even if a receiver is put in place, that does not mean that the person loses ownership of the property, correct?
Correct.
Yeah, because some people
Yeah,
misunderstand what that means. So can you kind of elaborate on what that really means?
sure. So, once the task of the receiver is complete, whatever it is the court has directed the receiver to do is finished, we discharge the receiver. So that cuts off their role in terms of being involved with the property in whatever aspect they were appointed for. Um, they then file what's called an accounting, and in this accounting, they're supposed to lay out all of their efforts at dealing with whatever it is the court um, deemed important to be solved at this property. So that accounting, which the building owner has a right to respond to and object to, appropriate, is the court would then um, approve it either as filed or maybe suggest some other uh, outcome relative to the work performed. And if the owner is not able to um, pay the amount the receiver has incurred within a reasonable period of time, then the receiver can then um, ask the court for the issuance of a certificate, and that certificate becomes a lien on the property to protect the receiver's position relative to the repair undertaking. Um, so I don't really. I was trying to think of a quick example I could give you, but um, this accounting results in an amount that the court would approve. Once the court approves it, uh, the certificate can be issued, and certificate is a lien on the property, but it must be recorded like any other lien, and it's essentially done that way to protect the receiver's interest.
And in terms of the receiver's cost, does the court um, does the court monitor, or does the court set the limits in terms of what a receiver could actually bill or charge for any particular service? I think your screen froze a little bit. I don't know if you can. All right. Judge Murray's screen is froze, so we're waiting for hopefully that to re-engage. So what I'm asking of the judge is to respond to the receiver. Does the receiver have unfettered, or do they just set whatever the costs are, or does the court have the authority to set whatever the limits are relative to whatever the service is that a receiver may have to render at that particular one? Hopefully, we'll get the judge back in just a minute. So, but the truth is, and the facts are, is that for those of you who have properties and you have been faced with some sort of inspection situation that has caused you to be called into court, to the housing court, the court really is there to work with the owners in terms of giving the owners the opportunity and the time to really obtain the wherewithal so that you can go in and you can make those corrections. So it's not set up so that you can take property. You hear people say, well, they just want to take our properties, they want to take my properties, and that sort of thing. Well, certainly not from the perspective of the court, and certainly not under the supervision of Judge Murray. I've been before Judge Murray on other cases, and I've certainly have monitored his courtroom and see how he works with them. I've been before his bench myself with properties that I have acquired that had some existing safety concerns and health concerns or violations that needed to be addressed. And so, and again, they have the inspectors, and then you have your commissioners in place to monitor this entire process to make sure that whatever the problems are, that the problems are alleviated, and that the property is in good condition and good standings for someone who either lived there or is going to live there. So so that's really the purpose and the mission of housing court and building court. So if you got any questions relative to that, you can send your questions through the comment. And if we are able to get Judge Murray back, I know that he was on the road because he's also campaigning and doing this first run, as we call it, this first run at the legal hour of the podcast that we'll be doing every Saturday. So, get your legal questions together, and then you'll be able to ask Judge Murray your legal questions, and he will be able to answer your questions. It doesn't have to be limited to housing. Judge Murray has been a judge for a number of years. He's handled a number of different cases, and he can answer those questions. Like, again, he is not there to give you he's not there to give you legal advice. He can't give you legal advice, but he can certainly give you instructions and information on how the court works and how the law works on certain particular areas or whatever that is germane to your particular situation. And so this really is an informational time that we want to provide information to you that you could use and or that will be helpful to what you're doing, as well as is to introduce Judge Murray to people who have never had to go before him. But if you've gotten a ticket, whether it be a parking ticket, whether it be a red light camera ticket or a speed camera ticket, and you wanted to contest that ticket and you went down to the administrative process, and the administrative process ruled against you and found you liable for that, and you want to appeal it, you have the ability to administrative review and go before Judge Murray's court. Judge Murray is back with us. All right, Judge. All right.
Yeah, sorry. I think
Yeah.
next time I'll make sure I'm stationary with a laptop so we don't have the connectivity problem.
Yeah,
Yeah.
I understand. Okay, fantastic. So, we're the question that I was about to raise on behalf of people is that the court is not set up to take people's property.
Yeah, not at all. That's not the outcome that we're looking for. We're really looking for uh, to allow the property owner sufficient time to bring the property back in compliance, because that helps all of us. It helps the community, helps the property owner to not be under the scrutiny of the government entity involved in the situation. Uh, the occupants of the property are in a housing condition that is productive and safe. So that is the goal. Uh, and within the confines of that goal, um, there are these rights that a receiver does have, but typically there are things that are worked out such that um, the owner is not under duress or threat of losing your property. Um, in some instances, uh, uh, the receiver will actually sell its lien to the government unit. I know in the city of Chicago, many times that lien is sold to the city, and they will hold it for a period of time in order to um, allow the property owner to reimburse the city. And then sometimes, depending upon the nature of the reason why the case was filed, the lien is forgiven totally. The debt is forgiven. So the owner has no additional responsibility to repay it. Now,
And go ahead.
Mark, we should also make sure that it's clear that receivers can only be appointed by a court. So those cases that um, are filed at the administrative level, uh, those hearing officers, as I refer to them, have no authority to appoint a receiver. So it's only in those circumstances where the case is in the circuit court that a receiver can be appointed.
That's a very important point. So at the administrative level, they cannot appoint receivers. It can only be appointed by the court itself.
Correct.
So the at the administrative level, they only have the limited ability to assess fines and fees um, on someone who um, is not in compliance.
Yes. And normally, depending upon the case, there could be a case fee added on to whatever the fine is. It's usually uh, somewhere around $300. Maybe just depends on the circumstance. Um, sometimes the city uses uh, outside counsel to handle certain cases. I know with delinquent water bills that they're typically prosecuted at the administrative level, and they use outside law firms for that. And there is a attorney fee amount that can be added to those claims, um, but it's usually somewhere in the range of $300.
Yeah. Okay. And how are receivers? I mean, are they licensed by the state? What determines a receiver, or is that someone who is appointed by the court itself?
I often quip that I could appoint Donald Duck as a receiver. I have one of those two 10-letter words that I say a dangerous discretion in order to do that. Um, so it could be anyone that the court believes is capable of completing the necessary repair that exists in that particular instance. Um, and to some extent, it requires some personal, or at least some resources on behalf of who the receiver is. There are corporate receivers and individuals who act as receiver, but you've got to come up with your own money in terms of funding the project, so that whatever it is that uh, the project is, and of course, um, the court can't force anybody to be a receiver. You know, they accept the role, uh, but the money to do the repair and also assembling the right crew to do the repair, that's all on the receiver. And typically, the receiver is entitled um, to charge for their time in addition to what's out of pocket. And the range is within the court's discretion. Usually it's somewhere around $175 an hour for that time, but it depends. If there's something more complicated or difficult, then the court could increase the hourly rate that a receiver is paid because of the task. Um, now, over the last several years, I want to say 3 to 5 years, in order to attempt to increase minority participation in the receivership effort, the Dearborn Real Estate Board has put on what they call a community receivership project, where folks interested, and they come from all walks of life, have taken this course. It runs over, I think, about 3 days, and it deals with receivership, other aspects of the court system as it relates to how cases are generated and filed. Um, but at this point, um, I don't know that there have been many folks who've come out of that program and have been appointed receivers. Now, uh, I am also proud of the fact that I appointed the first black woman as a receiver in Cook County, and that was about 3 or 4 years ago, where a woman who apparently was I think it's MWEB, um, or is it MWB,
Yeah.
certified
Hmm.
um, um, to do work for uh, Chicago Housing Authority, and it's lunchtime, and she sees me, knowing who I was. I had no idea who she was, and she says, "Judge, you should see my portfolio. I do work for the CHA." And she unveiled her portfolio, and I said, "You should be a receiver." Um, I said, uh, "Come to my courtroom this afternoon at 1:30, and there's a case I think that I can appoint you on." And that's in fact what I did. And as far as I know, that is the first black woman ever appointed a receiver in Cook County.
Wow, that's that's good to know. Do we know who that person is?
I know her name. Let me think if I can
That wouldn't be
remember.
Tamika. Wouldn't be Tamika Holt, would it?
No, that's not the name.
Okay.
Uh,
Okay. All right.
yeah.
Yeah. Okay. All right. Well, look, that's going to do it for this week, Judge Murray. Thank you so much for coming on. We'll be back here every week with Judge Murray at 1 o'clock on Saturdays doing the legal hour. So we want to give everybody an opportunity. Get your legal questions together. You can send them in. Certainly, you can put them in the comment sections, and we will read them off to Judge Murray, and he will address your legal questions. But that's going to do it for this week's edition of the Legal Hour on the People Show with Mark Wallace, and of course, Circuit Court Judge Leonard Murray, who is also a candidate for the appellate court. So we want you to certainly support him for his bid to the appellate court, moving in that direction. Just before we go, give us a little, in closing, a little bit about that court that you are running for that seat, and what your experience in this court will aid to your experience as an appellate court justice.
Well, anyone involved in litigation has an absolute right to have a decision from a trial court uh, reviewed by an appellate court, and the conditions is that the case must essentially be over, meaning all the issues in the case have been decided. There's nothing else for the trial court to do. Now there are certain circumstances where an issue can be sent to the appellate court earlier than that, but they're few and far between. But essentially, you have an absolute right to have an order from the trial court reviewed on appeal. Um, Whereas uh, not every appellate decision or even trial court decision uh, has an absolute right to be reviewed at the Supreme Court, our state Supreme Court. Uh, it was a time when we had death penalty in Illinois, where uh, those cases were automatically um, reviewed by the appellate court. But we, of course, Illinois abolished the death penalty a number of years ago. Um, but beyond that, any adverse outcome you believe you received from a trial court, you can seek review of it. There is a process involved in doing that. You first file a notice of appeal, and then you have to present the record from the trial court, meaning what occurred, papers and such, orders entered, so that the members of the appellate court can determine whether or not they agree or disagree with what occurred there. It's similar in function to what happens on administrative review, and I think I heard you, Mark, mention that a bit, where if you are not happy with the outcome you receive, from the city's administrative tribunal or any administrative tribunal, you have a right to ask the circuit court to review it. So it's a similar process where a circuit court then acts as a reviewing body from a decision um, at the administrative level. Um, not trying to suggest that they're the same, but they're similar. In fact, in my division, we handle cases from administrative review. And our numbers are down now, but at one point in time, we were probably doing at uh, least 2,000 cases on administrative review a year. They were about 200 a month, so it's actually a little bit more than that. But the process is very similar. So I have, in terms of filing your petition for review, the record, which on administrative review, the body who conducted the hearing is obligated to file the record there. So it's not on the person who seeks review. It's on the governmental unit that, in fact, conducts the process. Um, but in any event, uh, it would give me a chance to serve on a different level of the court. It would be a different experience. I did handle appeals as a lawyer, um, so I'm familiar with the process. Um, Probably a lot more, um, well, maybe more writing, maybe not more reading, but certainly more writing would be involved. But I look forward to the challenge that would be presented by that, and also it's all it's every type of case that is heard um, by the circuit court. So the appeals come from divorce. They
Oh, I think we lost Judge Murray's feed there again, but again, he's running for the appellate court, and so um, we I'm asking you for your support and vote for Judge Leonard Murray in his bid um, to the appellate court. He's also having a fundraiser that is going to be taking place on Friday, March the 8th at 5:30, from 5:30 to 8:30 at the Obsidian Social Club at 5401 South Wentworth Avenue on the south side, and that is number 17E. So you'll get a chance to meet the judge there. So if you want to go there, Friday, March 8th, 5:30 to 8:30 at the Obsidian Social Club, 5401 South Wentworth Avenue in number 17E. On next week's program, we're going to talk about the 13th Amendment, something that I have been very concerned about. In fact, it was the very first question that I raised when I was a law student back in 1982, when I went to law school, about the 13th Amendment and the language of the 13th Amendment. And I still have problems with it and don't know why it hasn't been um, addressed. And you don't really hear many people talking about it. But we're going to talk about it next week on that. And that language is on the 13th Amendment to the United States Constitution, abolished slavery and involuntary servitude, except as punishment for a crime. So slavery is legal if, in fact, you have been convicted of a crime, and as punishment, slavery. I have serious problems with that language in the Constitution, and that slavery is a punishment for a crime. So we're going to talk about that next week on the program. So make sure you tune in to that. I'm going to be raising that issue with legislators, with lawyers, judges, because I think that language needs to change in the Constitution and state constitution, as well as in the United States Constitution. So we're going to talk about that. I'm going to be raising that question to Judge Murray. And I want to thank you all for joining the program this week. And